Casual employees are people who are contracted for a brief period of time, and after which the employment comes to an end. Sometimes it's within maybe 3 months, it's quarterly and reviewable. Then home workers, this mode of
Hello,
employees,
good morning, sir.
yeah.
Sir, please, I hardly hear you. I don't know if I'm the only one.
Well, I also hear you correctly. So once I'm
I,
hearing you correctly, you should be able to
Hello,
hear
sir.
me also.
I think you
Is it
should
not
be the
correct?
only one.
Okay. So
Because I can hear clearly.
very well. So try to adjust yourself and maybe you may hear as well. So we're talking of home workers. Home workers are people who are employed for specific, usually in US and UK. These are where those employers are most. That one, you are employed to take care of maybe aged. These are home workers. Or some people are also employed to do cleaning services in people's home and private homes. This pool of employment are largely located outside. Then seasonal employees, like it is said, they take it from the word season. It's periodic. Maybe during Hamatan season, there's certain jobs only come within season. Some jobs arises when uh, maybe the employment or the company ran out of stock. So they will lay off all the workers and they will be re-employed at appropriate time. And some of those workers are in Ghana. If you go to some of the factories, you do that. They also deal with the employee probation period and the trial period. We'll deal with it in details as we go ahead. Then this is also saying that an employee is not a self-employed. A self-employed person or independent contractor. Very good. This person, independent contractor, where you have a contract like building, where you have employed or independent contractor. They are like people you give like a building. That one you have negotiated a price and you pay the person to start, or you give the person advance to start work. Now, such a person is an independent contractor, and is not subject to your direction anymore. These are the people who call them independent contractors. The contract has been given to them. They have negotiated the price one off, and they are not paid any month or wages anymore. It's a whole contract that has been given to them, and they will also go and employ other people to come and work on the contract. These are what we call independent contractor, and they are not subject to the direction of the employer anymore. These are what we call them uh, other self-employed or independent contractor. Then a volunteer too is not an employee. A volunteer is a person who has elected to work for somebody, but is not expected to get any money. Mhm. So when you have agreed to work without pay, you are not employee. You are a volunteer. The
Sir, sorry
volunteer
to
is
distract
not
the class. Sir, please, the page. You said you are using the.
page 28.
Sir, please, you said.
Page 28 of the book.
Thank you, sir.
Mhm. So a volunteer is not an employee, and we call somebody a share maker. A share maker is like a partner in the business. The person is contracted, but he has a share in the company. He is not expected to be paid. He's not an employee of you. He's not under the direction of anybody because he's also a shareholder. Or like he himself, we have agreed that we should work so that the profit that can you share. Such persons are not employees. Real estate agent. Real estate agents are special agents. When we do agencies, when you do agency in business law, you understand it's also a category of agent, and they are self-employed. They only take the business from you. They charge you, you pay them. So they are not under your direction anymore. Once the person is not under the direction of somebody or somebody, the owner, in another word, the principal, then that person is not employee. Mhm. Okay. Now let's talk about the types of employment or employees. We said a full time. On that one, we have even said explain them up there. But let's go over because there's some. But like I said, the part time, the full time, those who are in employment, the full time, those who go for employment, an average hours of 38, and that's how the law has defined it. But we in Ghana, we know full time are those who have been employed and they go to work every day, and they're entitled to salary in Ghana. When you're entitled to salary, you are entitled to be paid your senate and tax. Then you are for full time employment. It means when you get up in the morning, you go from 6 to 5. Then now you are in full time employment. But when you go 6 to 12, then that may be a part time. Mm-hmm. So the law talks about the hour, 38 hours per week constitute. So if the person works around 38 hours each week, then that person is a full time. These are definitions for the advanced country. In Ghana, we don't define it that way. Our definition is that once you get up in the morning and you go to work and come every day, it's a full time employment. But if you get up and you go to work and come maybe the midday or some days, then that will be part time. Mm-hmm. But the casual workers, like we have said, it is a periodic employment contract, and often it is for 3 or quarterly, 3 months, subject to renewal. If after the expiration of the period, the employer does not renew it, that's all. You have no action against the person. Then fixed term and casual workers are almost the same, but fixed term may not be a year, maybe about 4 years, and that one, as I said, is for senior positions. If you go to regional hospitals and this hospital, the directors are having what we call a fixed term. You are employed for say 4 years. After the 4 years, they will still or they will reopen the vacancy for application, and it's subject to renewal. That one you may go first if it's renewed once. Second one, that there cannot be a third renewal. So these are what we call a fixed term contract employment. Mm-hmm. Then shift employer workers too are people who changes. Maybe you come in the morning, one come in the evening. This is what they said we were told to be the 24-hour economy. I think one of it is supposed to be the shift. One will go in the morning, one goes in the evening, and it takes the same pattern. Then daily hire employee. Daily hire employees are similar, as it says, similar to full-time and part-time. They still get entitlement each such an annual leave or sick leave. So when we Ghana, we only have this thing. One now you go every day, and that's your employment. You go every day, that's your employment. But for part time, you may have the first one, and you'll be doing the part time differently alongside. Maybe when you close, you go and do. These are part time. Like we are doing in respect of your discourse. It's a part time job. What we are doing in the weekend and things, these are part time. But the building and
Sir,
construction is where we are independent contractors. Yeah.
sir, please, sorry, talking about the casual workers. Some of the institutions, when they employ some of the people as casual workers, they pay their SNIT and they
Mm-hmm.
treat them equally like they treat the permanent staff. So when they
Mm-hmm.
start paying the SNIT, so do they become permanent workers or still casual workers? Because some of the institutions, they don't.
Good. Paying your Senate is not a condition precedent for the nature of the employment. No. If it is one day, The person is entitled to pay Senate. Senate is the person entitlement. It's like his pension, a contribution that an employer is supposed to make, and you're also supposed to make for yourself. Now the law asks that anybody who is in gainful employment. Now even we have non-formal Senate contributors, those who don't do official or formal employment, who are not in formal employment, who don't receive salary, can choose also be contributing to Senate, and that one's for them. And we have a lot of people who do that. So if you are working and the person, the employer is not paying, the person offends the law. Now even the law, the Pension Act gives Senate power to prosecute employer who refuse to pay for the contribution of their workers. And that one has nothing to do with the nature of the employment. If it's casual or daily, the employer is entitled to, is enjoying to pay the employees contributions.
Okay, sir.
Very well. So we are talking about building and construction workers. We have the plumbers. These are all contracts, independent contractors. If you contract a plumber and he's working on your project, you have agreed with the fixed amount that you pay by the cost of the work that he will do. Now, if he come with workers, those workers are not subject to your direction. When they are not subject to you only know the plumber. There's the supervisor, because he is the person you have contract with. If you bring anybody there, so when during the construction he caused or those worker caused any harm, you only tackle the contractor, the independent contractor that you contracted. So this is how those types of employment also operate. It's a weekly hire employees, those who go for weekly and they come back. And there are a lot of employment like that in Ghana. Usually the manufacturing sector, those who go at night and do packaging and things. Sometimes you go week and the work ends. So you'll be paid by the week. And sometimes these are the people who are paid by hourly rate. Number of hours that you work. But these are found in the industrial areas. Then probation. If employers can put the employees on probation to assess if employees are suitable. So probation in our law is allowed. The Labor Act put probation period 3 months, but usually people treat it 6 months. It depends. Probation period, when you commit any offense against the rule, the employer is obliged not to even subject you for any disciplinary procedure, meet any committee. He can outrightly dismiss you. And after the expiration of probation period, the employer is not under any compulsion to confirm you. It is when the employer is satisfied that your work is satisfactory, therefore he can confirm you. So this is how it is. After probation, the employer is not under any compulsion. So he decides whether he will agree. But usually our rules is that once you have worked for 6 months, the employer is enjoying to confirm you and proceed from there. So during probation period is dangerous period, and anyone on that period should be very careful, because once you commit anything, the employer can summarily dismiss you without hearing you. But after confirmation, then you need to pass through the procedure so that you'll be heard and those kind of things that you are entitled. That one, if after confirmation you are wrongly dismissed, then that one you can sue the employer for the recovery and for compensation for dismissal. There's one we call outworkers, and this is that outworkers are contractors or employees who perform their work at home in a place that wouldn't normally be thought of as a business premises. Okay, so like those who are sent on, and they said the common are the textile, clothing, and footwear industry, where you are taking to a special site to go and work and come. So the difference between employer and employee is that the employee is an individual who has entered into a contract or to work for another contract of employment. And a worker, as seen, is a halfway house between employee and self-employed status. So a worker, usually we use the word worker to be those who do menial and periodic employment. Their work ends within a period, and it's a seasonal workers for of a sort. They come and go. But employees are normally the permanent one, those who go for formal employment. But workers can be those who go on construction working environment. And they say the distinction in knowing whether the person is a worker for the type of employment the person in depends on the legal protection. There's some called legal protection only apply to employees. For example, the right not to be unfairly dismissed and to receive statutory redundancy payment. Usually, those type of employment are the formal one, the permanent one. That one, when you are in it and you are unfairly dismissed. But take note that you can only argue for unfair dismissal after your probation. If during the probation, the employer finds that your performance is not satisfactory, he can summarily dismiss you. But after your confirmation, if after 6 months the employer does not confirm you, the rule is that 1 month after the 6 month expires, you are presumed to be permanently confirmed. And listen to this rule. I'm repeating. If after the expiration of your probation period, the Labor Act says that 1 month after the expiration of your probation period, the employer has still not officially written to you to confirm you. Then after 1 month after that, if you are still in the employment, then you are presumed to have been employed. He does not necessarily, whether or not he gives you a letter or not, you are confirmed. That is the law. That's the labor law. But before the expiration of the probation period, the rules are different. But after the expiration of the probation period, 1 month after the probation period, you are presumed to have been confirmed, whether or not they give you a letter. So that is the rule, and take note of it. Then we have the safety and health and safety. Employers are an obligation to employees, and this one, Safety, Health and Safety Act states that it is the employer who is supposed to create an environment that the employee will work in to guarantee his or her safety.
Hello, sir. Sir,
Yes.
I would want to ask a question with regards to the probation.
Mm-hmm.
Okay, so let's take for instance, you were given a probation period of 6 months,
Mm-hmm.
and after 6 months, because you weren't able to satisfy or your work wasn't that much good, they also extended it for you.
Mm-hmm.
So that you can show yourself. With that one, how do you
You cannot
describe that?
extend probation. You cannot say you are extending probation. If
Okay.
the contract states that you shall be on probation for say 3 or 6 months, that is it. After the expiration of the 6 months, you can't say I'm extending the probation. You cannot. The law says that after the expiration of the 6 months, if you don't confirm the employee, either formally written to the employee that your employment has been confirmed, then 1 month after the 6 months or the 7th month, your employment status is presumed to have been confirmed. That's the law. It is by the operation of the law. It is not another discretion anymore of the employer. That's how the law states. So you can't say, oh, I'm extending this is to see that you will be satisfied. There's no law like that. I think that's okay.
Yes, please, it is.
Good. So it is not a matter of discretion from the employer. Say, oh, me, I'm extending it. No. So long as the expiration of the 6 months, any other 1 month after that, the Labor Act says that you are presumed to have been confirmed. It's a presumption by the operation of the law.
So, but can I also ask unfair dismissal?
Mm-hmm.
Some of the attribute that comes under it are
Mhm.
sexual harassment,
Mhm.
discrimination, and so forth.
Mhm.
So, would you say that someone is under probation? So, when
Mhm.
she feels sexually harassed or di- unfairly discriminated, the person has no basis of making a case legally.
You can. Those areas are strictly by the constitutional requirement, and that one, it is fundamental. It's irrespective of being either being employment, former employment or not. If you're unfairly discriminated or you are sexually being harassed, that one it is fundamental against the national law, and that one you can seek redress at any point. So that one has nothing. But what we are saying is that where during the employment you're on probation, usually in probation, if the employer thinks you have not done well, he can. Usually, if after confirmation, if the employer wants to sack you, he needs to state the reason. And also, if you have been accused of doing something, he needs to set up a committee, listen to your case, and you should also be heard before they can take that decision. But in probation period, those rights are not normally offered to the employee because you are already on trial. Try me, he say he's trying you to see whether you are good. So if something and he say he doesn't like you anymore, nobody can question him. But after confirmation, then he cannot make the argument without justifying it. But that has nothing to do with offenses that against the national laws. Like because sexual harassment is a criminal law. It's a crime. This discrimination too is a crime. It's against our constitution. So those have nothing to do with the dismissal. Dismissal, usually what happens is that the person can outrightly get up and say, "Oh, production there, so I'm sacking you." You cannot question him, or you are within the probation. But after he has confirmed you, there's a permanent contract, and he cannot outrightly cancel the contract without due process. I think okay.
Okay, sir. Please, sir. My
Mhm.
question is that what about casual workers? For instance, if production is low and you don't have much income to be able to pay them, can you lay them off?
Yeah, you can. But that's why you said casual workers. That's why you said casual workers. However, even if it's a permanent employment and production is low and therefore you're unable to pay, there's nothing forces you to allow them to stay except that you will be owing them. When things bounces back, you have to pay the balance. You only if you are, let's say you are paying 5,000 month, but production is not down. The employer need to call all staff and say that owing to our current state, we are unable to pay salary for there. So when production bounces back, you are supposed to pay them back. But in respect of casual workers, that's why the word is casual. Once he takes you, it is for a short period. So while doing the production, if you realize that he can rightly lay you out without any back pay because it's casual. But the period that you have worked there, you will pay. Because that one, often casual, they are paid on hour rate. Maybe the number of days that you work and the number of hours that you work. So if there's an outstanding one that they have not paid, you can sue for recovery. I have a similar case that I'm dealing at the some high court. That's what it is. It is this mining company, and I think the company has gotten to manager one. Please excuse me 1 minute. Okay, thank you. We are back. So, like you said, casual workers are not. They don't have the same right like permanent workers. Permanent worker, even if your salary is old, it will be paid back. But casual workers, it is as and when there's a problem, immediately they will lay you off, and that one that's the nature of the job. That's why I say casual. They are often paid hourly rate. Mm-hmm. Then
Okay, sir, please, a follow-up question.
Mm-hmm.
Concerning part-time.
Mm-hmm.
For instance, a school that needs part-time teachers,
Mm-hmm.
is the school obligated to pay their senate?
Mm-hmm.
Because they are part-time. They work, they teach somewhere and they come and do part-time with you.
Mm-hmm.
Do you need to pay their senate? Because where they are working already, they are paying their senate.
The Senate, the law is that once you have employed anybody, if it is one day, you are enjoined to pay Senate. It is the case that because of the nature of it, mostly they don't pay, but they don't enforce it because sometimes you go and the employment has ended and they are all gone. So the Senate cannot even find the employer to ask for those things. But the rule is that even if you employ somebody one day and pay him, you are supposed to deduct his pay for his rate. That's the law. It's immaterial, the nature of it. And that's why I said we also have non-formal Senate contributors, those who are not in formal employment, but they like to pay because it's for their future. Including tax. Any employment you are supposed to pay tax. That's why because tax are paid for what you earn. But because of the nature of how those employment are, you are unable to find them to even tax them because they done, some of them done in houses or private. So where are the tax officers going to find them? But otherwise, every employment is taxable. I say okay.
Yes, please.
Okay. So the next distinction
Sir, please.
yeah.
Yes, sir. Sir, so please, like in terms of unfair termination of this thing,
Employment.
employment. So,
Mm-hmm.
what are the necessary actions that you can take against that
Okay.
person?
Very good. Why you have been unfairly defeated,
Yes, sir.
then you have unfairly dismissed you or terminate the
Yes, sir.
employment. Good.
Yes, sir.
You first have to make what we call you see your lawyer. The lawyer will write to them by way of demand notice for them to restore all you all to bring you all to restore your employment to you and give you within 2 weeks. After 2 weeks, if it's not, you only petition labor commission for it. But sometimes it is either labor commission or the court. But if it has to do unfair termination, the labor commission that has the jurisdiction. But I would normally, of course, when you go to high court, the employer will raise the preliminary objection that the court do not have immediate. You have to exert what we call local remedy. You go to high court, labor commission. If you are not able to get justice, then maybe you proceed to court. But the first point is that you give them notice, or your lawyer will give them notice of your intent to issue legal action if they do not do the needful. Then after which you can proceed to you petition labor commission. They invite them. They will try the matter there. Then if the labor commission find that your employment was unfair, they will direct the employer to pay you either restore your employment, and that one normally, and this is the advice. The difference between the law and practice. In practice, no court will direct that you should be reinstated if it is private in employment. If the business sector whether it has no branches, the court will naturally not do that because you are going to live with the person. But he unnecessarily terminating your employment, there has been a hostile relationship between you. Now, if you go and live in one room with that person, the person may even concoct something on you and destroy you.
Yeah.
So usually, if they are branches, the court will order that you should be transferred to other branch. It only works mostly in the government jobs. That one is where you are found to do. If the termination was unfair, then can either you should be reinstated. Perhaps the only fair thing that management will transfer you from that office to another. But otherwise, that is the rule in it.
Hello, sir.
Mhm.
Hello, sir. What if you are permanently employed and because of because the work is going down, you are being laid off? What are some of the things that you are supposed to enjoy?
You are saying that
When you are permanently employed
Mhm.
and because the work is not going on, you are being laid off.
Mhm.
What are some of the incentives that you'll be given?
Good. That is why companies are supposed to undertake employment policies because some of them redundancy uh, insurance policies. So that when the business, like you were saying, in that situation, it is neither the fault of the employer nor you. We call it a natural occurrence because the business itself is collapsing. And so the employer cannot get the money to pay you. So in that case, if the company, because they are enjoined by the law to undertake what we call a policy for such eventualities, so that during those periods, then they fall on the insurance company to find some compensation and give it to you to go. That way you have nothing. When the business has collapsed, you don't, because the business is under liquidation process, and any asset of the business will be liquidated to pay any outstanding salary and all those liabilities. Then you go. It is a risk that you go in. If indeed the business is collapsing, but not that you have unfairly been your appointment unfairly been terminated.
Okay. Thank you, sir.
Any question? Allow
Yeah.
you the question that you have. Okay, then we go to another criteria, which is the tax. Like I said, every employer is responsible for deducting tax. We have what we call income tax. So it is the duty of the employer to pay tax, to deduct the tax from the employee's pay, add his own, and go and pay to the tax authority. The same way the Senate is now 18.5. So you take, I think, 5% from the employee's pay, then 13.5 from the employer. Then you add up, making 18%. Then it goes and pay to the Senate. This is the law, and it is immaterial with the nature of the employment. If it is part time, if it's one day you are supposed to, but because of the nature of it, though, some of them don't pay. Particularly private schools and things, they don't pay. Some of them are owing, and now the Senate, the law has also empowered Senate, where it is also now an offense for the employer to deduct employees Senate from his pay, but not be able to pay, but not go and pay. If you don't go and pay, it's a crime, and the employer can be arrested without that. And you also have insurance. Somebody asked this question. That's why I said the employers are supposed to take liability insurance, to cover the risk of employees, like when you are injured at work, and also for redundancy. So these are all insurance policies that the employer is supposed to undertake. So that in the event of the company being liquidated, then you follow the insurance company to defray any outstanding debt, including pay, to compensate your staff to go home. Then liability, employer is liable for acts done by employee in the course of their employment, and that is true. While you are at work, any liability that you incur in course of your employment, the employer is supposed to compensate you. He's supposed to pay. Like you have been sent to Accra and you incur some loss or something, or you were injured, then the employer is under obligation, and it's a law that he pays all your electricity bill, No, that is your medical bills. Then if you are permanently being disabled, then that's why we have safety and permanent disability package. They are supposed to also compensate you, and that one too, Senate has it's part of the Senate law. There's an amount that maybe during your employment, you become permanently disabled and you're unable to continue. So they'll go to Senate, the Senate will give you a lump sum as a compensation. And that's how it is. Then we have a volunteers. They said legal status of volunteers is not clear out now. There is a vast, the issue is that a volunteer is not entitled to pay. If you have volunteered, you have elected to do the work free. You are not a worker. And the employer is not bound by your, this anything that happened to you during the work that you chose to do. So that is that. Because once you're employing the person ought to know that he's entitled to pay. And that is it. Now, the general meaning and the type of employer, we generally say that
Sorry, sir.
for those who have done business, accounting, we call something separate legal entity. Once you have incorporated business and the company is there, the company is different from the individual controller, if like the managing director. So the employer is the business, it's not the managing director. Let's get it straight. If you are working in an organization, something limited, then it is the company proper that's owing you. So when you're taking as you don't write the managing director name. He's not your employer. He's also an agent. When we do those who do agency, you will know. So your employer is the business. Like Ghana, if you're a government worker, your employer is the government of Ghana, not president. Not president. President is also an agent of the government. So these are things that we should. So company, entity, professional body, these are the employers. If somebody want to talk.
Please, I have a question.
Mm-hmm.
This is Paul.
Mm-hmm.
My question is related to the volunteers.
Mm-hmm.
Last week you mentioned that if somebody works in your premises, whether you have given the person employment letter or not, so far the person is found in your premises constantly, it's deemed as though the person is employed.
No, that I said. That's not what I said. Hold on.
Okay,
Put it. What I said was that so long as the person has been coming, what shows that the person is employment? That at the end of the day, you pay him.
Okay.
When you give him money, whether or not you give him appointment letter, give material. The key element in employment is pay.
All right.
If you don't pay him, then he's a volunteer.
Okay. So in that case, volunteers, must we let them sign documents to prove that they are volunteers in the event of
who is a volunteer?
Somebody who is working for free.
Very good. So if you are working for free, why should I sign contract for you? So there's no liability. I'm not liability against you.
But in future, if the person says you have been working for you,
have you been paying him?
No.
Have you been paying him?
But what about just giving the person tips, but it's not pay?
Well, if you choose to give, but that one is not a recognized pay. It is as and when you have it. Is that not so?
Yes, please.
So it's not fixed that every month you give him this. Is that not so?
Yes, that's it.
Good. So that one is not pay.
All right.
It is a gift.
All right. That's okay, sir.
Oh. What? Hello. Yeah. So, like you said, if you don't pay the person, The person is a volunteer. But if you give him gift is not a pay. Now we have the section 2. That's the essential element of a healthy employment relationship. One is mutuality. We have been saying that respect is reciprocal. So if employer respect the employees, employers are expected to respect the employees and value their effort. In the same way, the employee is also supposed to handle the employer's facility and assets with utmost good care. You don't work for somebody and do it anyhow and destroy his assets. So it's mutual. Once the employee is enjoying to respect you, you're also supposed to respect the employer as well, and it is reciprocal. That's why it's a mutuality. If I respect you, you have to also respect me at work. You don't treat me like an animal because I'm working for you. No. Then the second one is boundaries. Then once there is a specific, the specifics will vary among companies, but there must be boundaries between the employer and employee to maintain a healthy relationship. Close personal association, including dating, should be avoided. That's what we call sexual harassment. If your employer, you don't be taking the employees to, you don't be dating with the employee and expect the same respect. You see, and I can't say that. I think you all understand. Some of you understand. What we are saying is that if you engage in relationship, a moral relationship with employee, if your employer engage in a moral relationship with employee, they will not respect you. Mhm. And the HR policy manual must state all some of those things that are forbidden, and it must be published on the notice board of the company. Then there should be open communication. There should be periodic staff debate to explain so that people do not speculate under the working environment. Hello. Somebody called. So we also have open communication. There should be open communication that people do not engage in speculation at the work environment. The employers and for that matter, management is supposed to hold periodic staff debate with employees so that they can air their concerns and also solicit their views. It is good to continuously hold those fora so that you can be able to appraise yourself about what exactly happening at the work, because you are always sitting in their condition. If you don't come down, you will not know. So open communication too is another essential element for a healthy employment relationship. Then support. Employees can't do their job well without access of the proper resources. So where tools and resources to work are not available, the it is the duty of the employer to provide them so that they can do their work well. They should be able to work in an environment that is safe for their health and continue to work for the employee. There's one that we call gratitude, and this one is a moral requirement for the employees. The bonuses, raises, the bonuses and promotions, this one are supposed to also help in maintaining a healthy employee-employer relationship. Because if one particular year, the year has been more successful and good, you have to give it 13 months salary. You don't always be shoving them and be investing them for your personal gain, because the employees are the greatest asset every employer will have in his organization. Mhm. Then it's very important of a strong employment relationship. Employment relationship makes for a strong employment relationship, you gain what we call retained loyal employees. When there is a strong employment relationship, what the company gets there, you retain loyal employees. People become loyal to you. Even when people are conspiring against you, you will they will tell you so that you are not taken by surprise. And that's one benefit of strong employment relationship. Then there's also fewer workplace conflict or what we call uh, labor turnover. When we talk about labor turnover, the rate at which people leave employment and people come in. If your company is such a way that every day people will resign and you go employ, mind you, when the person resign and you employ, when you start job, the person begin to make mistakes. Mistakes also are very expensive or cost the company. So these are some of the things you need to engage in a healthy employment relationship so that people do not resign. And that one, if they keep resigning too, it also affect the reputation of the company. Yeah, when we don't do that. So where there's a strong employment relationship, it also there is less workplace conflict. You don't even hear strike and industrial actions.
Hello, sir.
Yeah.
Please, under the gratitude,
Mhm.
there's a company say sometimes they give the workers food, lunch, and breakfast. Can we classify it under gratitude?
It can. These are what we call the work side conditions of the employment that makes the employment. Of course, like you were saying, is also gratitude because it motivates the employee to come to work on time. One, because he may have to prepare food before coming, but he knows that when he can, he'll get food. So
Okay.
you can always get him at the work side, and it's
Okay.
a motivating tool.
Okay. So thank you.
Good. So, like we are talking about the element of a strong employment relationship. We are saying that first, it helps in retaining loyal employees. Then also, it lessens conflict at the work site. The industrial action may be reduced. Then also, it will increase productivity. People will give up their best. That's all. And these are the three major benefits of maintaining healthy employment relationship. Then in achieving the employment relationship, what do you have to do? You have to motivate your employees. And one of them can be like you were saying. One of them can be like what you were saying.
Okay.
1 minute.
Please, is it my network or?
No, I think
Oh no, he will
He
join us
asked for
soon.
1 minute. He asked for 1 minute to receive a call.
Okay, thank you. Yes.
Hello, forgive me. I had a call. So, like in achieving strong employment relation, you employers are supposed to motivate employees. Motivation can come in a different form. Like you provide lunch, you provide annual maybe annual bonus. You give clothing allowances. These are all motivating elements. Then you also need to set goal. You cannot begin to blame the employee when you have not given him a specific goal to achieve. And it is another same goal that you can use as a basis for promotion. The person should be able to achieve his objective. And you have to also assist the employee to also achieve their desire. if they want to pursue further studies, it is the responsibility of the employer to also. That's why we give what we call study leave allowances and who. Then employee want to give up their bed when there should also be delegation. Give the employee work to do. You don't employ the person as an accountant and you go and sit down without working. If the person sit down without working for a whole lot of time, he will lose his skill. In advanced country, you can sue the employer for a loss of profession. But here, because of this is what we don't do. But in advanced country, it's done. When you employ the person, you have to let the person do that work. You don't give the job to somebody while the person has the official be employed for that duty. To that. And there should also be effective communication. Then the last one is embracing equality. If you are giving everybody 5,000, all manager 5,000 with first degree, it should go acrossly. Equality is not equity, but it should be like last time somebody was saying, if all of us have first degree, we came the same time. Amount that's given to the person, it should be across. Unless the employer is able to justify why those people will receive from the different from the other, depending upon the nature and the duties of that particular department. And people should be able to understand. Not necessarily all of you receiving the same thing, but people with the same workload should be able to receive the same pay and the same entitlement. Once those things are happening, there will be a strong employment relationship. Any question?
So please, if you want to establish a business with someone like partnership, what are the legal proceedings to take up before you set up that partnership business with someone?
You said you want to do what?
Establish business, like partner with someone, establish a business. And I'm asking, what are the legal requirements or proceedings to take before?
If you want to establish partnership, it is covered by Partnership Act. You agree and you register with the rest of companies. Then that one within your partnership agreement, there should be the entitlement, the percentage that you all receive, the control of the business, all need to be stated in your partnership agreement.
Okay,
Is that clear?
it's clear. The next one, in a situation whereby someone set up his or her business, but at that moment, the person have no resources or money to pay you, but asks you to come and handle the business. And as time goes on, when things go well or when profits start coming, then we start paying you small, small.
Is
And
it
you
me that I'm
agree.
not hearing your voice well, or maybe on my phone? Well, yes, I find your voice so far.
Okay, I'm saying, can you hear me now?
Mm-hmm.
In the situation whereby somebody establishes his or a business, but he has no money to employ you at that particular moment, but he asks you to come and work with him or her. So that as time goes on,
Mm-hmm.
when the business become out, then he will start to pay you. And you agree and you work with the person. And later the business goes well, he start making profit. And he decides to employ different person, paying that person and then ignore you. Do you have can you take sue the person or do you have any legal action against that person? Or not at all?
If the person asks you to come and be a partner of a firm,
Yeah.
is that what you're
Yes.
saying?
The business is for him, all right. But
Yeah.
at the point in it was telling there's no money to pay you for now. So you just work
Mm-hmm.
with him, like helping him. And as time
Mm-hmm.
goes on, when things go well, he will start paying you. And you
Mm-hmm.
agree. But later, when things go well for him, he employ different person and decide not to
Oh,
work with you again. And I'm
and
asking,
take
at that
you
moment, can you off? Yeah.
take you rather off.
Yes, and employ different person. I'm asking at that moment, can you sue the person
Yeah,
or
yeah,
there's
that
no
one you can take
law
action.
action?
You can take action against him. You can take.
Okay,
Mhm.
thank you.
Okay. Now we proceed with the section 3, the basis of employment relationship. Basically, why there's a need for employment relationship is that when the relationship exists, very well.
Sir,
I'm listening.
please, regarding the question that my brother asked, is when you have your appointment letter or without an appointment letter too, can you sue?
I keep telling you that appointment letter is not a condition precedent for that. Appointment letter is only formalizing the employment. But he has been working with him all this while. He was receiving pay all this while. Appointment letter had nothing to do. Of course, he doesn't deny that he was in employment with him. You understand? So appointment letter there, it only make it formal. So appointment letter is immaterial. I keep telling you that once you have worked with the person for at least a period of time and he's been paying you, it means there's employment.
Okay.
Appointment letter does not formalize the employment. Appointment letter is only used in the formal sector. But once you are working for him, you work with him and you've been paying for over 6 months, you are in employment. So whether or not there's appointment letter is immaterial.
Okay, so that payment can be used as an evidence at the court, right?
Yeah. If you are working and the person is not paying you there, then you can say that you are not in employment. But once he's paying you, you are in employment.
Thank you very much, sir.
Okay, sir, I have a question. So, with regards to NAPCO, when the government initiated this program, this program was supposed to last for 3 years, and we were given letters to that effect. But along the line, as we were supposed to be like, they told us, or they even gave us some letters that they would want to absorb us into the system. And here is the case that when the program was even ending, there was no
What is happening? Hello?
Hi, we barely hear her.
Hi, sir.
It's from her network.
We are here.
Okay, I'm hearing you.
formal something to like make the
You were saying that the in respect of the NAPCO
yes,
one, NAPCO
yes.
one, it is clear that it was for a contract employment. You understand? And I understand it was
Yes.
for at least 3 years.
Yes.
After the expiration of 3 years, the employer is under obligation to either renew it or not. And I think after the expiration of 3 years, the employer refuses to renew. You cannot take him on.
The employer refuses to take you on, but I think it should be formal. Like you will be given some letter to vacate from the work premises. But what here is the case, nothing was said to you. Your pays, like your salary that was supposed to be given to you for like a period of time wasn't paid and all of that.
But
How?
within the 3 months that the first appointment letter stated, you were being paid, right?
First 3 months, yes.
The 3 years for the employment, you were being paid.
Not all the
During the
months. Not all the months. Even the 3 years, they are still owing 1 year. They
okay,
are
within the
still
3
owing
years.
some months. Yes, they are
And
still
then that
owing
one,
some months.
you can take what
And
we call
even
a
they
class
can't even
action.
give you. Sir, come again.
If there are still within a 3 years contract, there's an amount that still the employer is supposed to pay you, then you people can take it to court. But you cannot take it to court individual because you have a similar, they say. You go what we call a class action. People of the same category come together and you issue a rate against the government. You will pay.
Okay. Okay, sir. Thank you.
Very well. Any question? Okay. So unit session 3. We are talking of the basis for the employment relationship. Why is it the need? What makes it necessary that there should be employment relationship, a cordial employment relationship at the work site? And they are saying that the employment contract, there are two types of contract for the employment. One is transactional contract. These are the formal contracts that are well designed terms of exchange between the employer and employee, which are often expressed financially. And in a transactional contract, these elements are supposed to be found in the rational contract. They are largely formal, informal. And like we said, there are certain elements that even if they are those informal employment, even if they are not stated, because those informal employment, they don't go with appointment letter, but they are presumed to be in it. Every employment is supposed to have roles that you will have to play, the position that you will be held on, and the pay level, and the incremental pay structure. If you are not giving, they are presumed to be with it. Then express are those that are in writing. In writing. So when they are writing you appointment letter, then they need to state everything in it. And you might have gone for an interview. For them, there should have been an advertisement stating the position. You go for interview. They will first do shortlisting. You go for interview. Then after which you will be written. Your appointment letter will be given to you. Then they tell you that you are supposed to start. They are supposed to state the probationary period within which you work, and after which you are supposed to be confirmed. These are what contain the express appointment letter, and these are often contained in the collective agreement between the employer and employees. After receiving the employment letter, you are supposed to also write to accept. Please, 1 minute. That is why sometimes I have to. Though the employment contract must contain some of these essential elements, there must be an offer. And those who do the contract in the contract law, he said there should be an offer and acceptance. The employer must have offered the employee the employment. Then the offer letter must also create what we call legal relation. Legal relation means that the nature of employment is such a way that if one person does not perform his part of the contract, the other person has the right to go to court or to enforce it. That's what we call intention to create legal relation. These are elements of a basic contract. So first, there must be agreement. That's why offer one person should accept. Then that was your agreement. Two, there must be intention to create legal relation. It must be presumed that when one person does not perform his part of the bargain, the other person will have a right to seek redress. If you are supposed to pay me 500 and you don't pay at a certain level, the employee can go to court to enforce it. Then the terms must sufficiently be enforceable, meaning the terms should be in such a way that they are legal. You don't face time that cannot be, or they are not known to the law. There should be the terms that the employee is supposed to perform should be legal within our law. You don't tell the employee to, the role should not be legal in such a way that it corrupts somebody. That or evade a role that evade tax. These are illegal rule. Somebody want to talk? Okay, then let's proceed. So the third one is the terms must be enforceable. Then the agreement must be supported with consideration. Now the consideration is what is given in return of a promise. The employer offered to the employment, then you, the employee, should be able to give a promise that you work. If at the end of the month you have worked, the consideration may be either in kind or in payment. And in employment situation, the consideration is the work, your role that you play in that consideration. Then okay, sorry, I was rudely interrupted. Then the offer, the contract, the term must be expressed. Expressed, it must be stated clearly. The pay level, the number of hours the employee has to work, the holiday that he has to enjoy, and the pensions that he will, at what level will he be subject to in pension. Then there are also what we call implied terms. The implied terms are often not stated in the letter, but they are presumed to exist. They are often presumed to exist. That the conduct of the parties, each person is supposed to give a mutual respect. We have what we call custom and practices. Those terms are not stated, but they are presumed to exist. An employee is expected to know. Both the employer and employees are expected to know. And the terms implied by the duty of the parties to conform with statutory law. So all that you are doing to you as an employee, you are under responsibility to obey only legal instruction or lawful instruction. If your employer gives you instruction that are unlawful because you are an adult, when they ask you to engage in activity that are illegal, you don't do it. If you do, if you do it and there's a problem, you will be personally liable. And they are saying that your contract may also include a statement of the duties. Yeah, that one I office stated. Then they are all in a appointed letter. Then that there should be. So there's one thing we need to take note. Where your work in such a way that during the work you're able to produce let's say a document or textbook of a kind. Anything that you produce during the employment, it belongs to the employer.
Go.
Okay. Now we go to the common law obligation. The common law, like last time I said, the common laws are laws that are from the Commonwealth states, like a judgment of other countries. Though the common obligation of employers include the duty to pay wages, provide work, cooperate with the employees, and take reasonable care of the health and safety of the employee. These are common law requirements, and these are generally known within the Commonwealth states or the English-speaking countries. But they have the legal requirement, the statutory legal requirement. These are what is contained in our law in Ghana, our Labor Act. In every appointment letter should state the name of the employer and employee, the starting date, the commencement of continuous service, then the scale or the rate of remuneration. Yes. Then hours of work, the entitlement of holiday, and holiday with pay, then pensions and pension schemes, then length of notice of employee. the title of the job, disciplinary rules, and the additional work that will be expected. So some people's phone are mics are on, and please put them on. You are disturbing. Any question for session 3? Any question? For the rest are only small, then we conclude. Okay, then let's go. Let's brush through the session 4. We are managing the employment relationship, still managing the employment relationship. So how does the recruitment process take place? And that's what we are now doing. First, there will be announcement of recruitment, and it can come from either you in the dailies or on the notice board of the company. Then during the recruitment interview, you have to present to the employee favorable and unfavorable terms of the environment of the company for he to be able to get the picture. Then after recruitment, we go to what we call induction. As HR manager, you should make this in a point. Induction process is the program that you have to organize for the newly recruited staff, so that they will be acquainted with do's and don'ts of the company, so they will know the nature of the company themselves, the HR policies. Yes. Who is talking?
Sir, please, he's not talking to you.
Hello.
Look to that person.
Hello.
Of
Hello.
please,
Hello,
your mic, or
Yeah,
unless you are.
Peter, your mic is on.
Oh, sorry.
Okay. So after that, some people, some companies, after the interview and your employment, they do the induction before they issue your appointment letter, because you should be able to understand everything before they can issue your appointment letter to start. Then they will also give you a handbook containing all the HR manual and HR policies of the company. Then, by encouraging the development of the performance of management process, it also helps management to also be able to tell the employee the expectation during the period of their stay with the company. Then it also helps encourage the use of personal development plans to develop the company. And the HR process or development process also help by using learning and development programs. Then through the team, it also helps encourage what you call team work and the like. The rest we will read them. Let me go to the last one. I think a 5. That one talk. Yeah.
Peter, you said the issue and updates employees handbook. Please, I'm not getting this, sir.
During the after the recruitment and induction, the company will have to, because it's periodic, and the new policies that the company HR policy that the company have, they have to update the issue the employee with handbooks and any update that they have made from the previous one, so that they will be acquainted with the policies of the company. And that's how you give them. You are often that we call them HR manual. HR manual. That's why all the policies, the HR policies of the company is contained, so that the employee will be, not that you only speak to them, but they can be able to read and make reference. So they will be guided by it. So every employee, issuance of appointment letter, it should be accompanied with HR manual.
Thank you, sir.
Very well. Then the fifth one, developing a high trust organization. Meaning of a high trust organization is one in which high level of trust exists between the employee and management. A climate of trust is an essential ingredient. So in employment environment, it's a party. That's why we said one element of employment relationship should be mutuality. The employee, there should be a mutual trust between the employees and management. If they cannot trust management, you say you will give us increment in pay. Maybe after working hard at the end of the year, then you come and tell a story. Next time they will not trust you anymore. You understand? Employees should develop a trust with employees so that they can also give of their best for the mutual benefit of the company. And this is a very good uh, policy that every company is supposed to have. And it's very important for HR managers to always advise management at management meeting how we should be able to live by how they should be able to live by their promises so that the employee can also trust them. You don't, you tell them this, they follow, you do the other one. Now we are saying that when do employee trust when do employee trust management? Management is more likely to be trusted by employees when the employee believe the management means what it says. Observe that management does what it says it is going to do, and know from experience that management, in the words of Guest and Gunway, deliver the deal. So these are grounds upon which employees can trust management. Now, there is another point called distributive, procedural, and natural justice. Okay, these are purely law, and I'll explain it to you. To trust people justly is to deal with fairly and equitable. This thing, okay. Distributive justice refers to how rewards are distributed. People will feel that they have been treated justly in this respect if they believe that rewards have been distributed in accordance with their contribution. That they receive what was promised to them and that they get what they need. And like we said, I've said this a time with that number, that when you are giving bonuses or pay, it should be distributed in such a way that the employee will trust. You don't do it discriminately. You don't discriminate employees. Employees of equal workload and equal qualification are supposed to receive equal pay or equal reward. Any attempt to make to discriminate should be justified. If there's a reason why one person needs to receive more than the other, it should be justified. It could be from the performance. Maybe there may be a quantitative performance that would be the basis for which to be paid. Fine. But otherwise, in the absence of any other criteria, employees are supposed to be remunerated equally. Now, the procedure for the procedural justice refers to the way in which the management decisions are made. When Adwa fought with the other one, he was suspended 2 weeks. But when Akosua, in the glare of employee, insulted the manager, he was only given 1 day suspension. When you do this, you create environment that people don't trust management anymore. You understand? So this is what we are saying. The procedure for which you experience justice should be clear to everybody, that everybody will receive equal justice. It is not the issue that the person is an error, so he is being treated differently from somebody who is an account. We don't do that. This is what he said. And there are 5 factors that affect the perception of procedural justice. 1, adequate consideration of employee's viewpoint. Suppression of personal bias toward the employee. Applying criteria consistent across employees and providing early feedback So what we are saying that one criteria is that where employees' viewpoint are adequately considered. It shouldn't be in the stage that certain people are listened to and others are not considered. Then management is supposed to also act fairly and suppress their biases. You don't try to be biased against you try to give the environment, everybody, the benefit of the doubt, listen to everybody. You don't, when issue happen, you have to listen to the person first before you can take action. And we go to natural justice there. Then applying the criteria across board, it shouldn't be applied against other people, and others are allowed free. Providing feedback timely, and employees with the adequate explanation of decisions. So any decision that you make, you have to provide adequate explanation. Now there's a third one called the natural justice. Natural justice are in two forms. One principle is odi alteram patem. That means the principle is that you should always listen to the other side before making a decision. And as HR manager, this is one of the points you should take cognizance of. At any point there's an issue, listen to the other side before making a decision. It is arbitrary when a manager takes decision without listening to the other side. That's what you call natural justice. Then the rule against bias. You don't become a judge in your own matter. When a matter concerns you, the accusations, you are partly concerned. You don't sit on the matter. You don't be a judge on the same matter. That is against rule of natural justice. And that's what we talk of natural justice there. The individual should know the standard of performance and they expected to meet. So you let the person know and what you're expecting from you. You don't keep in the dark and tomorrow you're supposed to get 5. You are supposed to perform up to this level and you didn't do it. That would be unfair. They should be giving clear indication of where they are failing. So there should be periodic accounts so that they know where they are failing. Except in the case of gross misconduct, they should be given opportunity to improve before this will come. Not that this word should be heard. It shouldn't be improved. So you can cancel it and make it. Because when there's a misconduct, you should be heard before a disciplinary committee, before a decision is taken. You shouldn't improve. But that way, nobody expects you to improve. You should also state your side of the story. The renewing trust. Sometimes when management is strong, they should be able to admit that yes, we did this, so that at least if the people mistrusted you, they can renew it. Then a limited process of contracting, whereby a particular transition to a different way of working for a group of employees is done in form that takes individual needs into account. So where there is a need for change, workers need to be adequately be informed. You don't begin to inform, expect them to follow through. Then establish a knowledge-based trust. People should be given opportunity to showcase what they have. The manager should be able to listen. Then in achieving the trust, based on identification which each party emphasizes. So people contribution during decisions must also be identified. The last one is the theory, and there are only 3. Well, somebody should read the first one for me, so that I can know that you are also following. Read the labor process theory for me.
Okay, sir. Labor process theory. Labor process theory was originally formulated by Karl Marx, translated in 1976. His thesis was that surplus is appropriated from labor by paying it less than the value it adds to the labor process. Capitalists therefore design the labor process to secure the extraction of surplus value. The human capacity to produce is subordinated to the exploitative demands of the capitalist, which is an alien power confronting the worker who becomes a crippled monstrosity by furthering his skill as if in a forcing house through the suppression of a whole world of productive drives and
Good. So
inclination.
good. So the principle is that you might have heard him. He is saying that at any point in time, you should pay surpluses less than the value that the person has be able to add on, because the organization need to also benefit from you. But where the employee has made excesses, he should be paid surplus on that. But it shouldn't be the same amount that he added on, because the company need to also benefit. So it ends up this process of the capitalist. When you talk about capitalist and socialist, how you might have heard, the socialist view is that everything that is made belongs to the state. The capitalist believe that individuals should be able to own their own property. However, in doing that, it should also benefit the company. And that's why I said, at the end of the day, yes, it will be done just to at the disadvantage or to cripple the employee eventually. But at least something should be paid to you to as a way of motivation. That's the principle. If you read them, you get other people too. That the Braveman notion on a theory also will be simplified. So that is that. Let's go to the agency theory. Yes.
Agency theory. Agency or principal agent theory indicates that principals, that's the owners and managers, have to develop ways of monitoring and controlling the activities of the agent. That's the stuff. Agency theory suggests that principals may have problems in ensuring that agents do what they are told. It is necessary to clear up ambiguities by setting objectives and monitoring performance to ensure that objectives are achieved. Agency theory has been criticized by Gomez, Mejia, and Balkin (1992) as managerialist. As Armstrong (1996) wrote, it looks at the employment relationships purely from management point of view and regards employees as objects to be motivated by the carrot and stick. It is
So
a dismissal theory.
in the law of agency, if you do business law 2, there is a whole chapter of agency. An agency is a relationship that exists between a principal and agent in dealing with the public or the third parties. Now, the agent is always there to work for the principal. Now, the agency theory says that at any material point, managers should set target for the agent to work, to know that this is what I'm supposed to do. And when they are able to done, or what they are done, they will be expected to pay this. But this is what, as you read, others are also criticizing that it's making the whole thing like a managerialist. You are only using the employee, set target for him. Then you work towards that. Without sometimes to taking account the other prevailing environment, other conditions that he works in. It's only going by only target base. And it is not also helpful sometimes. And this is a labor way of motivating or drafting motivating packages. Then the Essence theory.
The essence theory. Okay. Please proceed.
Essence theory sets out to explain organizational behavior in terms of the rewards and costs incurred in the interactions between employers and employees. There are 4 concepts. 1, rewards. Payoff that satisfy needs emerging from the interactions between individual and their organizations.
Good.
Cost.
So reward is always that the employees always want what motivating what he get out of the I don't know what his work. That's the payoff. That's a reward theory first. The what much are you giving to the employee to also get his service, and that's a straight way without taking consideration of other prevailing factors. The 2.
Fatigue, stress, anxiety, punishment, and the value of rewards that people have lost because of lack of opportunity.
These are subjective terms, because yes, the cost that the person would have incurred in giving you of his best. That is why even when you are dismissed, court, if when the court is setting up the compensation package, the court presumed that after dismissing you, now that you are dismissed unjustly and it's not possible you can go back because of strained relationship, how much should he give you? The court will say that, and we presume that within the next 3 years, he will not get employment. So how much are you paying him every month? We multiply the amount that you receive a month times the 36 month. They give it to you as your compensation as a lump sum. So the court will award you that. So they take what would have gone through the court, the fatigue, the stress you would have gone all to make. So money. This theory also states that in setting up a pay or a motivating package for employees, employers are supposed to take consideration of some of those factors in setting up the reward packages. Then outcome reward minus cost.
If positive, the interaction yields a profit and this is satisfactory as long as it exceeds the minimum level of expectation.
Okay, so what we are saying that for there to be a trust in a working environment, the managers and employees should be able to engage in negotiation that will bring satisfactory outcome. However, it should be able to yield a proceed or if like more beneficial effect for the company in terms of the minimum level. Like somebody was saying, if the company is collapsing and therefore you want to lay off workers, there should be a good interaction. You should get them, and at worst you pay them the worst case scenario that you can get in the circumstances and ask them to wait for future. When things normalize it, then you pay them the difference. So this is what the exchange theory under outcomes works. That one, the reward that he received, and you take in the cost, then you give him the minimum. That's the worst case scenario that you can offer, so that the company too can remain afloat. The last one, level of comparison.
Level of comparison. People evaluate the outcome of an interaction against the profit they are foregoing elsewhere.
Yeah, so they compare with other company or their colleagues in other company. That okay, if you are accepting this, then what about others are also? And this one is done mostly by the union when they are in a negotiation with the management for pay. They try to use what other companies are also paying and what were the criteria that they are using to be able to accept. And that's what we talk about the comparison here. So in all, we have now come to know the relationship of that should exist between the employer and employee in a working environment. And we have also got to know that at all material time, it is good to for employers to set up a good working environment to be able to gain the result or the productivity, increased productivity for the company. Any questions so far? Well, but when are we meeting again? Is it next week, the same time?
Yes,
Yes,
please.
sir.
Yes, sir.
In absence of this question, I wish you well. Brother Sumjin coming in.
Council.
Amen. And counsel.